In August 2015, the FTC, the Federal Trade Commission, sued a company called Vemma, which is based in Phoenix, Arizona, a network marketing company, because it believed the company was operating a pyramid scheme. They froze the assets of the company and the assets of the owners of the company, pending a hearing that occurred a few weeks later. At the hearing, the judge expressed concerns about Vemma's lack of customer sales, according to the FTC's definition of customer, and the recruitment by to qualify emphasis within Vemma's culture. He ruled that Vemma could continue its operations for now, but only with significant changes to its business model. According to Vemma, it had plenty of customers. In its defense, Vemma said that affiliates who didn't buy startup packs or recruit any affiliates were in fact behaving like customers, and they should be permitted to be reclassified as customers. Part of the discussion was over this issue of who is a customer. And the court disagreed. What the court said was, we don't buy the argument that people enrolled as affiliates could be reclassified as customers if they weren't earning compensation through the company's pay plan. We think these affiliates are really failed affiliates. They're not customers. And they imposed very strict penalties upon Vemma to ensure that Vemma wouldn't create any more victims. And the Federal Trade Commission initiated an investigation and went to a judge and got an injunction. And as a result of a hearing that they had, they imposed a bunch of penalties on Vemma as a result of what they perceived to be improper behavior. The rules that they required of them, I can tell you, were very unusual. So I'm going to tell you what they said in their judgment. They said, you can no longer sell startup packs. What's a startup pack? A startup pack is a group of products that's designed to be sold specifically to network marketing representatives. Okay, so when you join the company, buy this bunch of product. And they paid commissions on those products. And so the court said, you can't sell those anymore. No packs, just for distributors. They said also, listen, if you're going to have a volume requirement, nothing that the affiliate personally purchases can count toward an activity requirement. These rules are highly unusual. There's nothing out there in federal regulations and laws that says you can't sell startup packs and you can't count personal purchases by affiliates toward activity requirements. Did the punishment fit the crime? The answer is no. They did some things that were problematic, but the courts, the FTC and the court's judgment against them was extreme. Definitely extreme. So, why are companies shut down? Let's talk about that. There's a difference between a pyramid scheme and a legal direct selling company. Most companies in this space are shut down because they are pyramid schemes, or they are Ponzi schemes. They are illegal businesses masquerading as legal businesses. That's why most of these types of companies are shut down. They are shut down because of insufficient customer sales. Vemma was not the first company to face this fate. Several years ago, there was a company called Burn Lounge. How many of you have heard of them? Burn Lounge. One person. Burn Lounge was an interesting model. Burn Lounge was selling websites where people could buy music. And they were selling concert discount packages, where you could be a mogul if you bought this wonderful website where you could sell music, and we'll give you discounts on concert tickets. And it turned out that 95% of the representatives bought the mogul package, and only 3% of the customers did. In other words, the mogul package was not for everyone. It was just for distributors. And that's one of the reasons why Burn Lounge was shut down and found to be a pyramid scheme. So clearly, lack of sufficient customer sales is an issue, and lack of what customers buy is an issue. So one of the things that the FTC was worried about in Vemma's case was they assumed that they were selling a lot of startup packs. Startup packs are only sold to distributors. They actually got that wrong. Vemma's recruiting had actually leveled off before they pursued them, and only 8% of their sales were in startup packs. The court thought it was more than 50%. So at one point it probably was, but at the time when they pursued them it wasn't. Okay? Income claim violations. You can make $1 million by joining this company. Product claim violations. It can cause you to, it cures cancer and does all these other great things. Clearly things that are illegal. Protected class violations. This thing cures acne. That's a protected class of people. This thing helps you live longer. Give it to people that have cancer. All sorts of things that are protected class issues and other questionable business practices. So there are direct selling companies that are shut down for very valid reasons. Was Vemma doing something wrong? Yeah, they were. I want to tell you one other thing that Vemma did that I would tell you is a cardinal mistake. One of the things in Vemma's compensation was this two-way of getting qualified for compensation. One was to buy $80 worth of product yourself. The other one was to sell $200 worth of product to customers. $80 in your own personal purchases or sell $200 to customers. How do you think most people qualified? But the product. It's a lot easier to buy $80 worth of product than sell $200. The court had a major problem with that. Major problem with that because they said you have a buy to qualify culture. People are buying the 80 because you've set the 200 as the alternative requirement. And I will tell you, direct selling companies should never, ever have a lower sales volume requirement for personal purchases than sales to customers. So, while a lack of sufficient customer sales has been one of the reasons that network marketing companies have been shut down or investigated, the Direct Selling Association, which is a lobbying organization for direct selling companies based in Washington, D.C., has been lobbying for years at the state level to pass legislation in several states defining what is a pyramid scheme. So there's a bunch of states that have laws that say, this is what a pyramid scheme is. But at the federal level, there is no legislation that clearly defines what a pyramid scheme is. Nowhere in the state anti-pyramid regulations is any mention of the prohibition or limits on distributor-based purchases. We are not willing to concede that a purchase by a distributor is worth any less than a purchase by a customer. And there is no federal pyramid scheme legislation in place today. So in the absence of federal legislation that defines what is a pyramid scheme, the Federal Trade Commission, which has very special and broad powers to protect the public, has taken matters into its own hands. They've become the sheriff in town. And they've petitioned courts for injunctions upon companies. They basically prepare a bunch of paperwork, give it to a judge and say, Judge, this company is so bad, you gotta shut them down, freeze their assets, you gotta take action. And a judge looks at the evidence from the Federal Trade Commission and goes, most of the time, okay. So in these cases where the Federal Trade Commission has done this, a lack of sales to customers who are not independent representatives has been one of their concerns, but not the only one. One of the things the FTC was concerned about, but they were also concerned about other questionable business practices. So in all of the documents the FTC has provided, they talk about this lack of customer sales, and then they talk about the other things. So, in May of this year, in response to the Vemma case, Representative Marsha Blackburn of Tennessee introduced the Anti-Pyramid Promotional Scheme Act of 2016. It's called H.R. 5230. It's a bill in the House of Representatives. It was referred to the Committee on Energy and Commerce. So similar to the state anti-pyramid statutes, this bill defines an ultimate user of product as a non-participant in the plan or a participant who purchases reasonable amounts of products for personal use and whose purchase is not made only for the purposes of qualifying for increased compensation. So in layman's terms, this bill was intended to prevent the FTC from coming after companies based on a lack of customer sales. So that was the Direct Selling Association saying, we need to introduce a bill that will stop the FTC from what they're doing. So this bill is proposed legislation that hasn't been approved. We don't know if it'll be approved, we don't know when it'll be approved, and we don't know what it's going to look like when it's approved. So at this point, it's the Direct Selling Association's attempt to say, we need to have a federal law that will stop the FTC. Now, the FTC isn't stupid. So the FTC's attitude is, we're going to do all we can to kill that law because we want to have the freedom to go after companies because we think this customer thing is really important. That's their position. So, what does Vemma mean for you? Does it mean nothing? Does it mean everything? The Vemma penalties, which were imposed upon one company, are not a law. They are a punishment for an action that a judge imposed based upon being petitioned by the FTC. However, the Federal Trade Commission and other courts look at most recent cases as precedents, which means in future cases, other judges may say, well, the Vemma judge said this, so I'm going to say that. So even though it's not the law, it's like in the absence of law, what do you look at? Other cases. Right? You look at recent cases. That's what you look at. So, if you're the owner or the executive of a network marketing company, you can either do nothing and hope the FTC doesn't bother you and the Direct Selling Association is successful in getting its bill passed, or you could take preemptive action. Action to increase the percentage of your sales that are made to non-participants in your comp plan. So we're going to talk about that. What are preemptive action? Number one, you can decide we are not going to encourage people to join our company as independent reps just for product discounts. We are not going to do that. So you have a decision to make. Are you going to not encourage people to join your company just for product discounts? How do you do that? How do you make it so people don't join just for product discounts? Simple answer. The price is the same whether you're a rep or not. You only pay the enrollment fee. You only buy a starter kit if you want to be a rep. If you just want the lowest price, be a customer. That's the first thing you can do. Second thing you can do is you can charge an enrollment fee that's high enough to be a representative that people don't become reps just for product discounts. I'm talking about setting a barrier high enough that people only pay it if they're interested in the income opportunity. We need to make sure that any required fee to be a representative is legal only if you don't pay commissions on it. If it's a required fee and you pay commissions, it's illegal. It gets back to we can't require our representatives to buy product to qualify. It's the same thing, just wrapped in a sales kit. Don't charge nothing to be a rep. Preemptive action. What else can you do? Sell stuff that people will buy even if they're not earning any money. What does that mean? That means make your products and services attractive to customers. You can't have customers if customers don't want your products. That's important. Charge customers a fair price. Whether it's the same price as your reps or a fair price, make it a fair price. And use sticks or carrots to increase customer sales. Sticks and carrots, what does that mean? A stick means you have to have them. Here's a stick. To qualify for compensation, you must have 3 customers. If you don't have 3 customers, you don't qualify. That's a stick. That says you got to have them. We're not going to pay you. A carrot says, listen, if you have enough volume between you and your customers, I'll pay you this extra bonus. I'll make it attractive for you to have customers. Maybe I'll have a revenue pool for people who sign up the most number of new customers in a month. They can share in a pot of money. You can do things to encourage customer sales. You can either take preemptive action or you can put your head in the sand. You have a choice as a direct selling company, and it has direct impact on your comp plan. Direct. The comp plan specifies the rules. Now, let's talk about Herbalife. In December 2012, it's almost 3.5, 4 years ago, a guy by the name of Bill Ackman, who's a hedge fund manager of a hedge fund called Pershing Square, decided to short Herbalife stock. He did this for a reason. What hedge fund managers do is they basically bet on the success or failure of a company. In his case, he said, I think I can get this company to go out of business. So what I'm going to do is I'm going to sell their stock short, and as an activist investor, he's going to do things to help hedge his bet. This is what he did. He contacted the FTC and he said, listen, you need to shut this company down. They are big and they are a problem. There's a lot of people that have complained. You need to investigate them. And the FTC went, okay, let me look at your evidence. And he began a research campaign to prove his accusation. Spent millions of dollars, created videos, created websites, talked to people, did focus groups, all sorts of stuff, and took all of his evidence and said, here, FTC, look at this. And the FTC started doing their investigation. All right. So, years went by. Years went by. He basically said they're a pyramid scheme and they should be shut down. Their stock went down, then their stock went up. It's been very interesting over the last few years. And on Friday, July 15th, the Federal Trade Commission and Herbalife jointly shared the agreed-upon settlement with the public. They agreed, they came to a determination of what was the penalty going to be. So, the interesting thing about Herbalife is 3 companies. It's a US-based company, it's a company based somewhere else, and a company based somewhere else. It's actually 3 businesses. So, the one that the FTC has jurisdiction over, which is the US-based business, is called Herbalife International of America. That company is responsible for 20% of their $4.5 billion in sales. So about $1 billion of their sales, the FTC has jurisdiction over. So Herbalife said, listen, we want to settle with the FTC, but we want to negotiate the terms. So for the last, I don't know, 6 months, they've been working on negotiating terms. Okay, and there's been these little rumors they're going to come out. A few months ago, they're going to come out with a decision, and then nothing happened. Last Friday, it did. So what did they do? The first thing they agreed to was a $200 million fine. Now, that sounds like a lot of money. Herbalife has $774 million in cash. So it wasn't that big of a problem. They agreed to a fine. What's the purpose of the fine? It's for the FTC and the court to dole out to injured victims. Who are they? I don't know. Remains to be determined. So they agreed to pay a fine. They also agreed to change their compensation plan 10 months from now. This is also interesting. Not tomorrow, not a year from now. 10 months, that's a weird number. That's negotiated. It was probably like the FTC wanted 6 months, Herbalife wanted 10. They agreed, wanted 12 or 24 or 36. They agreed on 10. So they agreed to change their comp plan. And they said, listen, we are going to put an independent compliance auditor on board for 7 years. For 7 years, you are going to be monitored. And you've got to get that person on board within 60 days. They said, we're going to have this new definition. This is actually interesting. We're going to have this definition that's called rewardable personal consumption. What they're trying to say is we're going to let your representatives count only so much per month as the basis for compensation. So if a distributor buys $3,000 worth of product, we're only going to let you pay commissions on $200. We're going to make it so that distributors only buy what they really need, including tax and shipping, right, for the next 12 months. And then, starting in month number 13, we're going to either change the amount from $200 to either $125 or, this is where it gets a little weird, I'm not going to get into the specifics of it, a calculated average amount of a specific subset of preferred customers that bought stuff over the previous 12 months. We don't need to get into the mechanics of it. The point is, the definition is going to change to be something else. And this rewardable personal consumption is going to be part of the basis of compensation upon which you can pay people. So we're going to let distributors buy product. We're going to let you pay commissions on it, but we're going to cap how much can actually come from distributors. This is different than the Vemma case, right? It's different. All right. Then, they said, also, we need to make sure that your total rewardable personal consumption, that's up to $200 per distributor per month, all of that is less than 1/3 of your total company sales. In other words, we want to see at least 66% of your company sales to not come from distributors. Okay, remember in the Vemma case, it was 51. So we want to see 66% of your sales not coming from distributors. What else? And we want to make sure that the total of customer sales plus the total rewardable personal consumption, this part up here, is less than 80% of company sales. Okay? They're doing this because their attitude is, look, if you want to survive as a company, Herbalife, you better have customers. So, in Vemma's case, they whacked him with one hammer. In this case, they whacked him with two. What does that mean for you today? Nothing, right? It's an action against one company. My personal opinion is, having customers, if it wasn't important before, it sure is important now. And by the way, having customers is a good thing, not a bad thing. Customers are good for business. It's a good thing. But it affects the design of your compensation plan. All right. You can't pay any compensation on non-rewardable personal consumption. They said Herbalife distributors will get paid only when at least 66% of their total sales, personal and downline, come from retail customers. That's the 2/3, right? So if 2/3 of your volume below you doesn't come from customers, you're getting nothing. Like the Vemma rule, except stricter. Not 51%, 66. Vemma only had to have 51. So they were tougher on Herbalife than on Vemma. Then they said, to get promoted or to qualify for your title, we are only measuring retail sales volume. Wow! So you're telling me a distributor can buy up to $200 a month. We can pay commissions on the $200 a month, assuming there's enough customers. But for rank advancement and rank qualifications, like if I have to have 100,000 points of volume in my downline, none of that volume can come from distributors. It all has to come from customers. And then they put this in. The number of points that you assign to a product can't vary based on who bought it. So they were worried that Herbalife might actually give a higher point volume to representatives who buy the product than customers. So they plugged this little hole here. All right, let's keep going. There's more. Distributors can't participate in auto ship. Wow, they didn't say customers couldn't. They said distributors can. What does that mean? It means something very interesting. It means if I'm a customer and I'm on auto ship and I decide to become a rep, I have to stop my auto ship. So they were so fearful that distributors were on auto ship just to qualify for compensation that they said, kill auto ship. And they said distributors can't participate in auto ship. My opinion is that's over the top and unnecessary. With everything else that they've got, it's unnecessary. But it's here. Then they paid attention to what Vemma was trying to do. Remember I said before that Vemma reclassified people? Vemma had said, these people that never bought a starter kit, that never sponsored anybody, that never did this, that are still buying the product, we're going to call them customers because that's what they're acting like. The court said a representative cannot be reclassified as a customer without their written permission. So someone can only be a customer if they agree to be a customer. Likewise, a customer can't become a rep without requesting it also. They also said before distributors can recruit others or earn compensation, they need to be trained. They need to be trained on the following concepts. Buy only what you'll sell in the near future. How you're supposed to document retail sales, which we'll talk about in a minute. The consequences of falsifying retail sales documentation. Prohibited and permissible representations. How to submit complaints to Herbalife and to law enforcement. They said we're going to have random and targeted audits to verify retail sales. Now, retail sales are composed really of two kinds of sales. Sales that are made by a preferred customer through the representative's website, where I go on, I order the product under Joe. I place the order, it's shipped to me, Joe gets the product credit. And product orders where Joe buys the product and resells it to me. He sold it to me. Well, the court has no problem with that as long as records are kept. Records are kept by whom? By the representatives and by the company. What kinds of records are we talking about? Specific data. First and last name of each purchaser. The contact information of the person who bought it. What you sold them, what they paid, how they paid for it, the date they sold it, and a signature if it was sold with a paper receipt. And they want that audited. The court's saying, listen, if you have retail sales, prove it. Prove it with the paperwork. Pretty severe. In the Amway case, back in 1979, when Amway was found not to be a pyramid scheme, there were some requirements in there about retail sales receipts, but no auditing. So today, there's no auditing of it. I mean, it's a requirement, but it's not audited. So, what does this mean for you? Nothing or everything? So, like Vemma, the Herbalife judgment doesn't apply to any other company. However, the FTC and other courts will use judgments like this against other companies in the future. So you have a decision to make. And your decision is, do I put my head in the sand? Do I pretend like it's 2013 and not worry about this? Or do I do something about it? And that's your decision.